February 12th, 2025. Welcome. Any announcements from staff to start us out?
I just want to start by making two announcements of thanks. First to the board members and all the participants in this morning's meeting for their flexibility with this somewhat different schedule. And I also want to thank CAPE and County Management for their quick and responsive facilitation of the board being able to resume meeting here in the Commissioners' Chambers.
Wonderful. Thank you. Moving to roll call of board members, starting over here.
Paul Wilzinski.
Gabe Quisenberry.
Andy Ball.
Josh Holmes.
Wesley Green. David Weinstein.
Thank you. Our staff.
Dana Alley. Savannah Glantz. Amy Broughton.
Griffin Kearns.
Thank you very much. Next on agenda, approval of minutes. We have minutes via email from our September meeting. Is that correct?
So there were two separate emails, each with minutes from yesterday, one set from January 8th of this year and the other set September 11th, 2024.
Any comments, corrections, or a motion regarding those minutes, those sets?
I make a motion to approve the minutes.
There's a motion. Is there a second?
Second.
Second that, yeah. All those in favor, please say aye. Aye. Any opposed, nay?
Aye.
That passes. Thank you very much. Moving to disclosure of ex parte communications or conflicts of interest. Any board member exercising quasi-judicial functions pursuant to the chapter general statute shall not participate in or vote on any quasi-judicial matter in any manner that would violate any person's constitutional rights to an impartial decision maker. And permissible violations of due process include, but are not limited to, a member having a fixed opinion prior to the hearing that is not susceptible to change, an undisclosed ex parte communication, close familial, business, or other associational relationship with an affected person, or a financial interest in the outcome of the matter. With that clarification, we will start over here again with that disclosure.
No.
No.
None.
No.
No. None.
Thank you. No's all around. Fantastic. Moving to our public hearings, we'll start out by saying that this hearing is a quasi-judicial evidentiary hearing, and that means similar to a court hearing. State law sets specific procedures and rules concerning how this board must make its decisions. The board's discretion is limited. We must base our decisions upon competent, relevant, and substantial evidence in the record. Our decisions must be constrained by the standards in the zoning ordinance and based on the facts presented. If you'll be speaking as a witness today, please focus on the facts and standards and not personal preference or opinion. General witness testimony is limited to facts and not opinions. For certain topics, though, this board does need to hear from opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion testimony must be qualified as experts and provide the factual evidence upon which they will base their expert opinion. Further on this, staff has done a great job in the recent weeks and months providing resources to the public for what the board considers criteria for standing applicants versus what is appropriate for witness testimony. So point of clarification there, those members of the public who are joining us to speak on a project either as a party with standing or as a witness, the board has to find that the party has standing to participate in a case and clarify the proper time for lay testimonies at the end of the hearing when the board may open up the hearing to consider witness statements. To be clear, if asserting standing in a matter before the board today, we would first need to conduct a hearing to establish that you have standing, meaning you believe you are uniquely affected by a project for reasons separate and apart from your neighbors. And if those elements, such as noise, traffic, or property value impacts that you have alleged, you prepare a case and have brought with you today, or are you yourself credentialed or qualified to present expert testimony in those areas. If that doesn't describe your intent today, please consider again whether you would like to assert standing or speak as a witness toward the latter part of the hearing. And with that, we'll move to the continuation of the Murray variance, that is ZPH 2024-00021. And Dana Alley can bring us up to date on where we are there.
Please raise your right hand and state your name. Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code. I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objections, so accepted.
This is the review of ZPH 2024-00021, the Murray variance. Applicant and owner is Sandra Murray. Project is located at 245 Rocky Mountain Way. Total acreage is .06 acres, and it is served by public water and sewer. The property is zoned R2 with no overlays present. The lot was created in 1996 before the adoption of the Buncombe County zoning ordinance and is considered non-conforming due to the acreage of less than the current minimum of 6,000 square feet. This variance is to request a reduction of the rear setback from 15 feet to 8.
Any questions for staff? And we've talked about this case, I think, twice now, so this is our third hearing. Thank you. Yeah. Will the applicant approach if they're here? You might go ahead and grab a seat at the lower tables here.
Prefer to sit
Oh,
it
I can sit.
down?
Oh, that
Yes,
Please,
that's
yeah.
absolutely fine.
Easier for everybody, yeah. And just check, make sure your microphone's on when you do sit.
Sure, I can hold on to those for now, and we'll.
Good
All
morning.
right,
Good morning.
I'm
First
going to
of
go
all,
ahead and
I
swear you
wanna-
in first.
I want to
So,
Yeah,
swear me
we'll
in.
start with
yes.
that.
All right, so please raise your right hand and state your name.
Sandra Murray.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome.
Good morning. And thank you for putting me first.
That's
I
nice.
appreciate it. If you could distribute those to the board members so I could walk them through my argument, I don't know, presentation.
Thank you.
Hopefully
An-
this will help clarify.
Another thing that I do want to mention at this time is that an
Yes.
application for standing was submitted in this case
Okay.
on behalf of the Hills at Avery's Creek Property Owners Association, so I'm not sure when that would need to be considered.
Should we usually consider that first? Was that recently submitted in the last month for this hearing?
I believe it was submitted within the past 2 days.
Okay, great. Let's, if you don't mind, we'll abbreviate this. We'll make
Okay.
sure they have standing first, and if not, we'll go ahead with you.
Okay.
Is that representative here? Thank you so
Mr.
much.
Billy Clark should be the counsel.
We'll have you sit, sir, if you can, and then we'll swear you in, and then hear you on standing.
He's an attorney, so we're not
Oh,
gonna
that's
have
right,
to-
yeah. Thank you, sir. Yeah. Yes, sir.
Aware that there have been communications with Savannah Glantz, between the POA and Savannah Glantz, about an application for a special use permit to have 0 setbacks for the entire neighborhood. And we just want to make sure that, obviously, we want Ms. Murray to be able to do what she needs to do, if that's the board's decision. But we also just wanted to let the board know that we are moving forward with that. It does take some time. We'd have to do a resurvey of the whole neighborhood. So I just wanted to make the board aware of that, and that's the interest of the POA at this meeting today, and the president of the POA is here and several other board members. I'd be glad to answer any questions, although I don't have a huge amount of information about it, other than the client has been in touch with Ms. Glantz, as I said.
We'll open up to board questions. And so we are to understand that the HOA has met on this issue and has voted that they intend to pursue a resurveying and re-permitting to allow larger.
That is
adjustment here.
that is their intent, Mr. Chair. I think they're having actually a formal meeting this Friday to authorize the necessary expenditures. But, so the plan is to proceed with that.
Okay. Did you then want to participate in the hearing as a party withstanding with cross-examination and evidentiary rights and all of that, if the board just intends to hear this matter on its own in advance of that application?
No, I have, the POA has no interest in that. We just wanted to make you aware of what's going on with relation to this.
Perfect. I tend to think we should take that under advisement and not continue with a standing petition. Yeah. It's agreeable, so I think so.
That's agreeable with me. Thank
We
you.
appreciate the update very much.
All right.
Thank you very much. Thank you.
So I'm on?
A positive interruption. There you go.
Oh, no, that's okay. In
Thank
the
you. You may
packets you've been handed, I've made printouts showing a section of our development. And the first page is the boundary survey, and my property is highlighted in yellow, and the number on it is 979. And on the next is a Google map screenshot. Sorry for the blurriness. And I've put numbers to indicate where additions have been made, just in this one particular area. And the numbers coordinate with the pictures that are attached behind. And the first picture is a good indication of how close to the edge of the property that some of the build-outs have been made, with very little property behind them. The first one is just artistic because I liked my sunset picture. But if you look on the map, coordinate, the number 1 is up in the upper right, and I'm going to circle around the circle that I live on, indicating the pictures so that you can see how close things are to the property borders that have been built out. And the pictures continue around the circle. And the ta-da moment is 10A, which is my property, which is bordering on a large expanse of grass in the back. And A indicates I had my lot professionally surveyed, and the red outline is my lot line, and it extends 20 feet back off of my property. And the inner black square indicates the size of the addition that I would like to put on, which is 12 by 15. And 10B, you can see the setback on the side and the expanse of grass that is behind my lot. And 10 is how huge the field is. So I'm not, my property is set back slightly from my neighbors, so it wouldn't even extend that far out into their visual field as my neighbor.
Okay.
And the last page is the approval notice I got from my board, which wasn't an easy process because I originally wanted to make the room as large as I could. But they wanted to conform to the visual appeal of the neighborhood and didn't want to obstruct anyone's view or
Sure.
have it too large where it didn't look proper, so. And the hardship I have is with the, being unable to add value to my property due to a setback zoning put in place in 2009, which was totally out of my control and was created out of my control.
Thoughts, comments, questions for the applicant from the board? Just to clarify, from staff's perspective, we can act on this independently, of course, as a reminder from last meeting. We discussed this before, but we can act on this independently, and then the HOA can move forward with their plans to make this an option for all the property
Yes.
owners. Okay, thank you.
My builder is here if you have any questions for him.
Perfect. And we have this in the application, we just wanted to get it on the record too. What's the total size of your proposed addition?
12 by 15,
12 by 15, thank you.
12 feet out to the back and then 15 wide.
15 wide. Okay.
So it
Fairly
would
straight.
be 8 feet back from my property line against the field.
Perfect. Well, if the board would like, we can go ahead and hear from any witnesses who are here to speak on this one. Okay. We will open up the floor to anyone here to speak as a witness on this matter. Who's here to speak for or against this matter? Going once, going twice. Yes, sir. Please. And there's a dais there, and we'll swear you in first.
Okay. Please raise your right hand and state your name.
John Downey.
And do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
Welcome,
Hi,
sir.
guys. How you doing today?
Doing great.
Yeah, I am John Downey from Airvid Exteriors. We do construction in Buncombe and Henderson County throughout Western Carolina. And we do sunrooms and screen room additions. So the biggest thing on this is what, I got a crash course from my project manager this morning, sorry. The zoning that was set back in 2009, was it, for R2 zoning is actually set for 0.09 acres or 4,000 square foot, which were Miss Murray's, and most of the properties here in this development actually don't even meet that criteria because hers is only 0.6 acres and 2,600 square foot. So honestly, the biggest thing, and if you look at the map that Miss Murray presented, there's quite a bit of properties that I haven't seen but until this morning that actually extend beyond those property lines already. So I think that's why the board for this community has decided to rezone the entire neighborhood. But I just think, for Miss Murray's stance of what she's trying to accomplish, it's gonna be an upgrade to the community. The community is gonna benefit from everything property-wise, and so will the county, in my opinion. So that's kind of all I have on that. It's just mostly the zoning is not correct as it sits today, so it needs to be rezoned accordingly.
Thoughts, questions, comments? Thank you, sir.
Yep, you got it. Thanks, guys.
Yes.
Thank you, John.
Make sure that you have Miss Murray's documents admitted as evidence if that's what the board is going to consider as part of its decision-making process.
Those are so admitted as Exhibit 1. All right. Any witnesses, any remaining folks here to speak as a witness? Going twice, 3 times? Thank you very much. Any closing remarks or final remarks before we close? the hearing.
Hope it goes my way.
Thanks for your patience and throughout this process.
Oh, thank you very much.
We'll close the public hearing at this time and open up for board discussion, deliberation, or a motion. And we have a variance here, so we will need 6 out of 7, 5 out of 6. 6 out of 6, that's right, because we don't have 7, okay. So it'd be unanimous here. Any comments?
This one's a little bit tough for me because from a feeling point of view, I absolutely think she should get what she wants. I don't think anybody's going to be harmed. The fact that it's a little bit further back makes it even less significant. But people keep reminding me that we have to follow rules, and sometimes I dislike that. But I don't see a hardship, much less an unnecessary hardship. The only hardship is that the applicant doesn't get to do what she wants to do. And to me, that doesn't fall into the unnecessary hardship category.
Can I speak to that?
We can open it back up if the board votes to do that in just a minute. I want to hear some more comments
Oh,
before we do
okay,
that, though,
okay.
before we consider that. Yeah. Kind of get a feeling of the room if we can. I will say on that note, though, and I would honor those comments, of course, but in the prior hearings, we did hear about the lot size being a certain size here, small size, and that being a factor in a hardship. We didn't hear it today. We heard it from the prior hearing. But,
I would love to hear somebody argue in favor of granting the request based on that.
okay.
So I look at this and I say the HOA is in favor of it. The HOA is looking to rezone it. It seems like a reasonable request. I don't see the issue.
I also see, while it doesn't conform currently, I think that I agree with that. I also think that there are other folks in the community who have made additions, whether or not they were before the ordinance or not, they exist and they're benefiting from those, of course. And of course, each lot in here technically is a different size. So that does lead me to think there is a hardship for some lots, including this one. So.
I think, Paul, you make a good point. However, I think if the HOA hadn't come forward and said their plans, I think that's a little bit different too. I think that makes more an agreement and creating an alignment for everybody to be on the same page.
And, temporarily here, this will allow this particular property owner to make this improvement. But of course, once the HOA comes forward and makes that change in the coming months, then the rest of the folks will be able to do that as well. So, other thoughts?
Yeah, let me just say that I'm easily convinced of the opposing argument.
Yeah, I think this also goes back to the timing of this development. Predated zoning. This zoning was imposed on these properties. It is non-conforming as it stands now. So it does create, it's not something that the applicant created or by their actions. Wouldn't necessarily be a knowledgeable, something you would know if you own that property. It was a restriction that came on your property after the fact. So I think that also weighs in addition to the POA saying that they're moving forward with a modification of that for this particular development.
Any other thoughts or motion? And there's a variance motion sheet somewhere hanging around. Well, first of all, before we do that, is there a need does the board see a need to reopen to hear from anybody? Okay, all right.
Mr. Chair, based upon the evidence presented to this board, I move that the board approve the request to participate in the hearing as a party. No, that's the wrong one. That's a deny. Findings of fact.
There it is, yeah.
That's request for standing. Yeah, that's what I started to read. Mr. Chair, based upon the evidence presented to this board, including the following exhibits: the petitioner's application, the submitted site plan, the GIS maps, the staff report, testimony presented at the hearing, I move that this board adopt the following findings of fact: that this matter was properly advertised, is within the board's jurisdiction, and is ripe for its consideration. That this application, together with the conditions proposed by staff and/or this board and agreed to by the applicant, if any, does meet the requirements for granting a variance contained in Buncombe County Code of Ordinance, Section 78-621, subsection 4.
There's a first of two motions on findings of fact. Is there a second?
I second.
Hearing a motion and a second, all those in favor, please say aye.
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 Any opposed, nay? That motion passes.
Based upon the foregoing findings of fact and for the reasons set forth therein, I move that the requested variance be approved and that the staff be instructed to draft an order consistent with this motion approving the permit with any agreed upon conditions for review and execution by the chair, acting chair, or such person's designee on behalf of this board.
There's a motion to approve. Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed, nay? Okay, that motion passes unanimously. That's approved.
I could cry,
Thank
I'm
you
so
very
happy.
much. At this time, we'll move to staff and our attorney's presentation of a order on this
One page,
case.
then it's become 4 pages.
Do you normally follow along on the screen or just have them read?
Normally, but really, if you want to zoom to the last section, we usually do that. And you can read through the whole thing or the last section that changes.
It's okay. Board makes the findings of fact that an unnecessary hardship would result from the strict application of the zoning ordinance of Buncombe County, that the hardship does result from conditions that are peculiar to the property. The hardship did not result from actions taken by the applicant or the property owner. The requested variance is consistent with the spirit, purpose, and intent of the ordinance such that public safety is secured and substantial justice would be achieved by granting the same. Based on the findings of fact, the board hereby makes the following conclusions of law. The application, together with any conditions referenced above, and there were none, satisfies the requirements for granting a variance contained in the Buncombe County zoning ordinance, and makes the following order: that the applicant's request for a variance from the zoning ordinance of the Buncombe County, let me say that again, that the applicant's request for a variance from the zoning ordinance of Buncombe County on the property is hereby granted as requested in the application this 12th day of February, 2025.
Thank you very much. Any questions about the order or a motion?
Thank you, thank you, thank you.
Motion to approve the order?
There's a motion to approve. Is there a second?
Second.
Hearing a motion and a second, all those in favor, please say aye.
Aye.
Any opposed, nay? Thank you. That passes. Thank you so much.
Thank you so much.
We appreciate you. We will go ahead and move straight to ZPH 2024-00037, the Spivey variance. Mr. Comfer is here to present that to the board.
Please raise your right hand and state your name.
Jacob Comfort.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes, sir, I do.
Hello.
Hey, good morning, board. Thank you for your being here today. I appreciate your commitment to development here in Buncombe County. I want to acknowledge and certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with the North Carolina General Statute and the Buncombe County Code of Ordinances. Furthermore, I ask that the materials provided by the applicant and staff be accepted into the record as evidence.
Seeing no objection, those are so admitted.
Thank you. This is a review of case ZPH 2024-00037 to request a variance for the parcel addressed as 610 Buckeye Access Road and designated by the parcel ID number of 9688077541. The current owners and applicant for the project are Benjamin Grady Spivey Jr. and Belzy S. Spivey, who applied for the variance on September 9th, 2024. The property currently has a detached garage and 2 single-family residences on it and totals approximately 1.07 acres. The proposed development will be served by a private septic system and connected to COA water service. The property is located in an R1 zoning district where the minimum lot size is 30,000 square feet, or roughly about 0.69 acres. The applicants are requesting that the board grant a variance to decrease the minimum lot size to 0.35 acres, or 15,190 square feet. If approved, this deviation from the ordinance would decrease the minimum lot size by almost 50%. The project proposes 1 lot at 0.71 acres, which is in compliance and would have the garage and an attached and the adjacent residence with it. The other lot would be the 0.35 acre lot and would just have 1 residence on the property. The board should carefully consider whether this strict interpretation of this ordinance results in unnecessary hardships and that these hardships are unique to the property and not a result of the applicant's own actions, which was granted by inheritance or I guess an heir to the estate. This variance request is only to decrease the minimum lot size requirements for R1 on this particular parcel. The board cannot take into consideration the intended use of the property when making its decision, and the applicants are here and happy to answer any questions you guys have. Thank you.
Thank you. Any questions for staff? Seeing none, we'll greet the applicant. Hello. How are we doing?
Good morning.
Good.
Chair
We'll go ahead
and
and-
board, thank you for.
I will,
Absolutely.
I'll
We'll
need
go
to
ahead and
swear you in
first.
one by one, so whoever would like to go first can please raise your right hand and state your name.
I'm Linda Spivey.
And do you swear or affirm to tell the truth and nothing but the truth?
Absolutely.
Thank you. And please raise your right hand and state your name.
Sharon Spivey Cox.
And do you swear or affirm to tell the truth and nothing but the truth?
Yes, I
Thank
do.
you.
Thank you both for being here.
Thank you. Good morning, everybody.
Try to keep it casual. We'll just do an intro to your case and kind of describe what you're seeking to do here.
Okay.
Yeah.
My father, Benjamin Grady Spivey Jr., who's on the ownership of the plot, unexpectedly passed away August 7th of 2021 with no will, and that left his wife, my stepmother, Linda, and me as an only child, joint ownership involuntarily. So we wish to split the house that she lives in at 614 Buckeye Access Road away from the 610 and the other building. The hardship is because of no will, we're joint owners, but we wish to do different things with our properties. And Linda has some health concerns, and she may or may not go into long-term care at some point, and we would like to split the properties also because if she had to do that with her property or sell it for some reason, we wouldn't want to entail all 3 buildings together. So we're in agreement that we want to split the properties. We had a survey done, and that, do you have the paperwork?
We do.
Okay,
Mhm.
so
The application, the survey.
it's already marked where we want the lots to be separated.
Okay. Are all the buildings on the surveys existing? There's no proposed buildings. They're all existing garages and houses and everything else? Okay.
Yes.
Questions, comments?
Yeah, I've got one question. What would be the effect on, I'll say your family, I'll call you your family, if this request for the variance were not approved?
Well, yeah, maybe you have a better idea.
Well, this would happen. If I were to have to go into long-term care, then the property would be sold, and it would all be placed into a situation where she would no longer have a home, and the business would no longer be there, and my home would be sold, and it would put her family out in the street. So that's why we need to have a variance in case I'm trying to protect the only child that I have and her home and her family. And at the same time, we don't want to put a hardship on the county to take me in and provide medical assistance. So I want to use my home for that if I ever have to do that.
Thank you.
You're welcome.
My only question would be about septic. Do both homes have their own independent septic system?
Yes.
Okay, great. And would your home, would the septic be contained on your lot with this subdivision? Great, okay.
Refresh me again, what would happen on the, the front parcel? I mean, the plan is to will it somehow, right? On the front parcel, the two structures that you own, that you would propose to keep?
Well, we're joint owners now, because of the no will that my father left. And she would own the 614, and that lot, I think it comes to like 0.35 acres if you split it. And then the other home and the garage would be on a separate plot, the 610 and 606.
And the back house would be owned by you solely on the deed? And then the front?
They're actually horizontally on the road, so.
Yeah, so on the right then? The single house would be on its own non-conforming lot of 0.35, that would be your ownership only?
Hers.
Hers only, okay. And then you would have the front two
Right.
buildings? Okay. Got it now, thank you.
And I will say, hers would be the 3.35. There are existing lots on the same street. I guess they were grandfathered in before the ordinance was passed that are also less than the 0.69 that the lots should be.
It
There's
looks
two
like-
that are 0.31.
Yeah, I was gonna say, it looks like on the left side, there are 2 or 3 or 4 lots that are all similar size that were pre, the zoning change.
Right.
Yeah.
Other comments, thoughts? Is anyone here to speak as a witness on this application? Any witnesses? Yes, sir? There's a dais up there. The mic should be on. This one up here, sir, if you want to. Yeah. And we'll swear you in first.
Okay, please raise your right hand and state your name.
Jamie Cox.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Yeah, one other point, I'm Sharon's husband. One other point is that for insurance purposes, we can't insure the entire property as it sits now. But it would be much easier to insure it if we had boundaries. If something happens at her house, then our insurance would have to cover it for liability purposes, but it may not, because we're insuring our property only and the property that we intend to own. So it kind of jumbles all that up, and we'd like to settle that just as another hardship to the situation.
Okay. Thank you. Were there questions or comments based on his? Okay. Would you also say that the shape of this lot and the fact that there are 3 structures sitting on it and 3 septics creates a lot of dimensional issues for the property to keep it as one?
It does, yes.
Okay. Are Other thoughts from the board before we close public hearing? Questions? We will go ahead and close the public hearing and open up to board discussion and comments and a motion. This is a variance as well, so we'll need to keep that threshold in mind.
I think this is a classic case of why we're here. This strikes me as rather straightforward. I would like to, make sure that they do have septics, but they've asserted that, so this seems kind of straightforward to me.
Mhm. I would agree with those comments. We will take a motion at any point then.
Mr. Chair,
Yes.
based on the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted site plan, GIS map, staff report, and testimony, I move that this board adopt the following findings of fact: that this matter was properly advertised, is within this board's jurisdiction, and is ripe for its consideration, and that this application, together with the conditions proposed by staff and/or this board and agreed to by the applicant, does meet the requirements for granting a variance contained in the Buncombe County Code of Ordinances, Section 78-6214.
Thank you. There's been a motion on findings of fact. Is there a second?
Second.
Hearing a motion and a second, all those in favor, please say aye.
Aye.
Any opposed, nay? Thank you. That passes.
Based on the foregoing findings of fact and for the reasons set forth therein, I move that the requested variance be approved and that the staff be instructed to draft an order consistent with this motion, approving the permit with any agreed-upon conditions for review and execution by the chair, acting chair, or such person's designee on behalf of this board.
There's an approval motion. Is there a second?
Second.
Hearing a motion and a second, all those in favor, please say aye.
Aye.
Aye. Any opposed? Thank you. That passes. Thank you all very much.
Thank you so much.
We'll move to discussion of an order on this matter.
Can you show me which board, please? We switched the view. Can the board see order?
Yes, we can.
Okay, great. Disposing with the caption, moving to paragraph 5 of findings of fact. This board finds that an unnecessary hardship would result from the strict application of the zoning ordinance of Buncombe County. The hardship does result from conditions that are peculiar to the property. The hardship did not result from actions taken by the applicant or the property owner, and the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice would be achieved by granting the same. The following conditions, which are reasonably related, should be imposed. There are none. This board, based on those findings of fact, makes the following conclusions of law: that this application, together with any conditions referenced above, satisfies the requirements for granting a variance contained in the Buncombe County zoning ordinance, and the board makes the following order. The applicant's request for variance from the zoning ordinance of Buncombe County on the property is hereby granted this 12th day of February, 2025.
Thank you very much. Any questions, comments on that order or a motion?
Motion to approve?
There's a motion to approve. Is there a second?
Second.
A motion and a second. All those in favor, please say aye.
Aye.
Any opposed? Thank you. That passes. Congratulations again. Thank you very much. Best of luck with it. We'll move now to ZPH 2024-00004, the Barns by Gorman Bridge Special Use Permit. And we have Savannah Glantz to present.
Please raise your right hand and state your name.
Savannah Glantz?
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with the general statutes and county code, and I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objection, those are so admitted.
Thank you. This is the review of ZPH 2024-00004, the Barnes by Gorman Bridge. Applicant is Marvin Odebear. The property is located at 330 Gorman Bridge Road, and the total acreage is 5.19 acres. It'll be serviced by public water and septic. The property is zoned R3, and the special use permit proposes a vacational complex of 8 units with 1 unit currently existing. And the application proposes no deviations through this process. If approved by the board, staff recommends the following conditions of approval. Project must meet all the pool on site can only be accessible by the main house, rented for one group at a time, and cannot be used by the other vacationers on site. The barn on site may not be used as an event space. The project must be constructed as depicted in the site plan, and applicant must agree in writing to these conditions prior to commencement of site work.
Okay, are there comments, questions for staff?
Yeah, I do. I'm looking at the staff report, and unless I missed it, there's one more thing on the staff report that has a whole bunch of subheadings, whole bunch of subs on it. This is prior to commencement of land disturbance.
Yeah, so underneath that, there are some subsections to that. I just don't list all of those, but that would be part of the, what the applicant agrees to as
Oh,
well.
okay, thanks.
Yes.
Other thoughts, comments from the board for staff? I think we're all set. Thank you. Has anyone submitted a standing application, petition that we know of?
Not that we know of.
Is anyone here publicly wanting to assert standing in this matter? We'll have an opportunity for witness testimony later on in the hearing. Going twice, 3 times. Thank you. And the applicant, welcome. Come on up, either one of these desks. Make sure your microphone is on, and we'll swear you in.
Please raise your right hand and state your name.
Marvin Odebear.
And do you swear or affirm to tell the truth and nothing but the truth?
Absolutely.
Thank you.
Welcome, sir. If you want to start with just an overview of the project, and we'll go from there.
Okay, so the plan is to on the front lawn of the lot to build 7 small cabins, approximately 500 square foot each, 1-bedroom units with a small road with a turning circle at the end, staying clear from the how do you call that? We have a how do you call that, setback for the power lines that are on the lot. And you know, it's that's the plan, and to expand it as a vacation rental complex, not extracting properties from the market, but rather building them ourselves, which I think is a good thing.
And plans to renovate the house then, the main house?
The house is already renovated.
continue.
We already closed all the permits.
Okay.
Was all done by the book, and the house itself is top 5 most appreciated. I don't know if that's relevant, but
Nice.
most appreciated Airbnbs, and we've had no complaints from any neighbors that we know of, and so we try to run it professionally, and we hope to get the approval to expand it with 7 more units.
Looking at the map here and the orientation, being familiar with the area, is the neighboring property to the north, the fire department?
Yeah,
Yeah.
right next to the fire
Okay,
department.
yeah,
Extra safe.
Helps with the insurance, right? Thoughts, comments, questions?
Just trying to reconcile some of the numbers. So there'll be a total of 9 units, because it says 7 cabins, 1 home makes 8, then 9 barrel saunas.
No, okay. So I requested that that piece of paper to be updated, but the barrel saunas are not part of the application. But there is 1 house currently, and we're trying to get approval to build 7 small cabins on the front lawn, so that the total will be 8.
So a little
And
earlier.
with the barrel saunas was a great idea, but I don't think we're going to do that.
That sounds like a great idea. But I'm just trying to determine, is it 8 or 9? Because it says in here that they're looking to build 9 in total.
Well, we had we hired Land Arm to do the soil research for the septic system and so forth, and they recommended we throttle back to 7 because of the flow.
Makes sense.
There'll be a separate driveway, a private street coming off Gorman Bridge for this, correct?
Correct, yeah. So it's completely separate from the main house, which is one of the concerns related to the pool being a public pool or not. But that house is going to be a separate entity, you know, that you can rent each of these units individually. So then,
Okay.
so they don't, it's not one complex. We have the permit for the driveways.
Okay. This is all one tract we're looking at on the survey that has, you know, it includes the high tension lines below.
Yeah,
That's all included, okay.
yeah.
And the cemetery is fenced off or will be, or
It's fenced off.
fenced off, okay.
And to alleviate the concerns of the owners of the cemetery, there was a right-of-way, sort of like, if you look historically, it's been for many, many years, decades. And there's been a driveway that goes technically over their lot into the back of our property. And to accommodate their concerns, I requested a permit to put a second driveway on our own lot, and we surveyed that, and we put a fence in between so that they don't have to worry about any disturbance from our activities.
That's nice.
Mhm. And we also paid for the HDPE pipe through their lot.
Other board comments or questions? Yeah, it is. I think so. All right, we'll ask if there are any witnesses here to speak on this matter today. Witnesses, going once, going twice. Thank you. Any final comments before we close the public hearing and deliberate?
Well, I hope that we're granted permission to proceed, and we'll make sure that it's an enhancement of the neighborhood, and we'll manage it very diligently, as we do with all our properties.
Thank you very much. Close the public hearing and open up to board deliberation and discussion.
Seems pretty straightforward to me.
It's well thought out, well presented. All right, we'll open up for any discussion or motion.
Mr. Chair, I'll make a motion to approve finding and adopt findings of fact Mr. Chair, based on the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted development plan, the GIS maps, the staff report, testimony presented at the hearing, I move that this board adopt the following findings of fact: that this matter was properly advertised, is within the board's jurisdiction, and is right for its consideration; that this application, together with conditions proposed by staff and/or this board and agreed to by the applicant, does meet the requirements for granting a special use permit contained in Buncombe County Code of Ordinances.
There's been a motion on findings of fact. Is there a second?
Second.
There is a second. Hearing a motion and a second on this. Any further discussion? None. All in favor, please say aye.
Aye.
Aye. Any opposed? No. That motion passes. Thank you.
Mr. Chair, based on the foregoing findings of fact and for the reasons set forth therein, I move that this requested special use permit be approved and that the order approving the permit be adopted and executed as presented and as modified in this meeting.
There's an approval motion. Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed, nay? Thank you. That passes. Thank you, sir. We'll move to discussion of an order on this motion, on this matter.
I have a draft order dispensing with the caption. This matter was properly noticed and advertised and was in the board's jurisdiction. The applicant has applied for a special use permit. The property is located in a residential 3 zoning district that the applicant and all other parties withstanding were given the opportunity to participate in this duly advertised and noticed hearing. That pursuant to Buncombe County zoning ordinance, the board finds as follows regarding the special use proposed in the application. 1, that the land within the PUD will be under single ownership or managed by the applicants before final approval or construction or proper assurances have been provided such that the development can be successfully completed by the applicant. 2, that the density is consistent with the intent of the district in which it is located and conforms to that permitted in the district in which the development is located. 3, that the land uses are compatible with and do not violate the intent of the zoning district and do not disrupt the character of the community. 4, that the proposed land use meets minimum requirements for land development as follows. A, the minimum lot size and requirements for interior setbacks do preserve the spirit and intent of this section and does comply with the density requirements for zoning district with respect to the local development, total development plan. B, the proposed height set forth in the application does comply with the spirit and intent of this section with respect to the total development plan. Where building heights exceed the maximum allowed by the ordinance, this board finds that unique elements of the development impose requirements for additional height that are not universal throughout the zoning district. C, this board finds that the minimum distance between buildings will ensure adequate air, light, privacy, and space for emergency vehicles. 5, that this development does provide reasonable visual and acoustical privacy for all dwelling units. Fences, insulation, walks, barriers, and landscaping will be used for the protection and aesthetic enhancement of the property and the privacy of its occupants, screening of objectionable views or uses, and reduction of noise. Multi-level buildings are located in such a way as to dissipate any adverse impacts on adjoining low-rise buildings and do not invade the privacy of the occupants of such low-rise buildings. 6, that the structures located on the perimeter of the development will be set back from the property lines and rights of way abutting streets in accordance with the property of the zoning ordinance controlling the district. 7, this board finds that the proposed parking does comply with the spirit and intent of this section. 8, this board finds that the conveyance and maintenance of open space, recreational areas, and community-owned facilities are in accordance with NC General Statutes 47-1, the Unit Ownership Act, and any other appropriate mechanisms as specified. 9, this board finds that the building envelopes are shown in the submitted plans and depict the maximum expanse of the proposed footprint of the structure. 6, that pursuant to section 78-677G of the Buncombe County zoning ordinance, satisfactory provision and arrangements have been made for at least the following as it relates to the proposed use will not adversely affect the health or safety of persons residing or working in the neighborhood. B, the proposed use will not be detrimental to public welfare or injurious to property or public improvements in the neighborhood. C, the proposed use will not cause or have adverse effects on surrounding properties due to noise, vibration, odor, or glare effects. D, satisfactory ingress and egress for the proposed use of the property and proposed structures has been provided. Particular attention has been paid to automotive and pedestrian safety and convenience, traffic flow, and control. E, provision of off-street parking and loading areas where required with particular attention to the items in section 78-658 of the Buncombe County zoning ordinance have been arranged for. F, provisions for adequate and proper utilities with reference to location, availability, and compatibility have been arranged for. G, provisions of buffering, if deemed necessary with reference to type, location, dimension, have been arranged for. H, signs, if any, and proposed exterior lighting with reference to glare, traffic safety, economic effect, and compatibility are in harmony with properties in the district. Playgrounds, open spaces, yards, landscaping, access ways, and pedestrian ways with reference to location, size, and suitability have been arranged for. J, buildings and structures with reference to location, size, and use are acceptable. K, hours of operation with particular reference to protecting and maintaining the character of the neighborhood are acceptable. 7, that the following conditions are necessary to ensure that the proposed use will conform to the requirements and spirit of the Buncombe County zoning ordinance. 7A, that the pool on site can be accessible by the main house, rented for one group at a time, and cannot be used by any other vacation rentals on site. 7B, the barn on site may not be used as an event space. 7C, the project must be constructed as depicted in the site plan. 7D, prior to the commencement of land disturbance and construction of activity, the applicant shall submit a site plan development permit for the entire project indicating the following: exact location of all the buildings and accessory structures, commercial lighting plan, buffering, landscaping, and parking lot landscaping if required, retaining walls, easements and rights of way, approved 911 road names, any other conditions of site development approved by the Board of Adjustment, and a copy of approved permits from the U.S. Army Corps of Engineers, NC Department of Transportation, and the North Carolina Department of Environmental Quality where applicable. E, this master site plan permit approval shall not replace the requirement of pulling an individual site plan permit for each building or structure within the development. Finally, the applicant must agree in writing to those conditions prior to the commencement of work. Based on the foregoing findings of fact, the board makes the following conclusions of law. The applicant's request for a special use permit, together with the imposition of conditions found necessary above, which are incorporated herein as if fully set forth, does meet each applicable requirement of the Buncombe County zoning ordinance. Now therefore, based on the foregoing findings of fact and conclusions of law, the Buncombe County Board of Adjustment orders as follows: that the applicant is hereby granted a special use permit to establish a planned unit development on the property as requested, subject to the conditions referenced above, which are incorporated herein as if fully set forth. This the 12th day of February, 2025.
Thank you very much. Comments, questions, or motion on that order?
Motion to approve.
There's a motion to approve. Is there a second? Hearing a motion and a second, all those in favor, please say aye.
Aye.
Any opposed, nay? That motion passes. Thank you again, sir. Congratulations. Best of luck with the project.
Thank you so much.
Any other matters staff has for us this morning? Any matters the board has for us this morning? Otherwise, we'll take a motion.
Mr. Chair, I'll make a motion to adjourn.
There's a motion. Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed, nay? Thank you very much. We're adjourned.